rights violations, and we defend activist campaigns against SLAPP suits, which we will briefly talk about today. So we also do a lot of Know Your Rights trainings. A big part of what I do in traveling around the country is training activists and targeted communities about what their rights are. And this training has been kind of geared specifically to an animal rights conference. We kind of cater them to whatever the group is that we're working with. We do a specific training for immigrant rights that's all in Spanish. We do a lot of them for teens right now. Which is probably the most challenging audience I have. We also do workers' rights and tenant rights as well. And the purpose of these trainings is to make sure that you are aware of where the line is drawn between legal and illegal. I'm not here to teach you how to break the law and get away with it. I'm not here to tell you that breaking the law is fine. You know, the idea basically is, a lot of, especially activists, we self-censor ourselves because we're not really sure what the law says. And so because we don't want to get arrested or we don't want to break the law, we actually censor ourselves and restrict our rights actually much more than we really need to. Also, just by way of background, I became a vegetarian at 7. I've been a vegan since I was 16. I do a lot of animal rights law, both wildlife and saving dogs from euthanasia to, you name it. I've probably worked on something similar to it. And so, I come from an environmental and animal rights background before going to law school. And I graduated from the University of Oregon School of Law up in Eugene, which is now where my offices are. So this is my contact info. We also do trainers trainings. So if your community ever wants to learn how to give this training, we teach communities how to give it so they can continue to provide it. Also, videos of me doing this training and the PowerPoints and all of our outreach materials are free and available on our website, which is cldc.org. And finally, if there is any questions that you think of after the fact, you're welcome to email me. Definitely just to remind people, you never want to ask a lawyer, I'm going to break the law next Tuesday, what am I going to get charged with? You always want to use hypotheticals. Lawyers are allowed to tell you what the punishment might be for a certain crime or what the definition of a certain crime is, but you never want to say, so next week we're going to go block this doorway, what could we possibly get charged with? Because technically lawyers, as officers of the court, are then supposed to get on the phone and report you to the cops. So never put a lawyer in a position like that. Okay, so this training is based on the US Constitution, meaning any state you go to, these rules are going to apply. If there are state-specific things, I will tell you that. And under the US Constitution, whether you are a US citizen or not, we all have the same exact rights when you are within the US or a US territory. We are going to primarily cover the Fifth Amendment, which is your right to remain silent, your Fourth Amendment, which is searches and seizures and warrants and things like that, and then your First Amendment, which is your right to free speech, but also your right to assemble, how you can plan protests if your intention is to ensure that they are legal or not. And a little bit of the Sixth Amendment, which is your right to a lawyer if you get arrested. So the Fifth Amendment is probably one of the most important. It's your right to remain silent. And literally the rule is you never, ever, ever have to answer a question put to you by anyone. The only person that can ever force you to answer a question is a judge in a courtroom. So wherever you go and whatever situation you ever face, if you're thinking in your head, do I really have to answer that? The question is always no. The answer is always no. You always have a right to assert your Fifth Amendment and not answer. In this PowerPoint, when you see words in red, we call those the magic words because we want you to memorize them. And the reason we want you to memorize them is because whenever people interact with cops, and I will use the word cop, I should have given this in the preamble. When I use the word cop, I'm talking about really anyone with a badge. Whether it's campus police, city, state, the feds, a security guard, you name it. They all are bound by these same rules that we're going to talk about. So I'll just use, I often just use the word cop as a generic for anybody with a badge or, undercover, et cetera, et cetera. So whenever you interact with a cop, your adrenaline starts pumping, everybody gets nervous, no matter how many times you've had the experience. And so we want you to memorize these words so that they will come out of your mouth instead of some of the crazy that I've had to read in police reports. The other reason we want you to use these specific words is because a lot of times these are phrased as legalese, meaning, normal people don't say, "I wish to remain silent." And we have found over the last 18 years that I've been doing this work that when people use these lawyerly sounding phrases, it changes the dynamic between you and the cop. All of a sudden, the cop gets a little more professional, or they'll say, "What are you, a lawyer?" Or, "Is your dad a lawyer?" And we've even had cops actually look behind them for cameras, thinking that they were like on a TV show or something. So, those are the reasons that we want you to use these phrases. And all of them are in our Know Your Rights brochures, which we brought some with us from Oregon that are out on the table, but you can also download these. We have them in Spanish. We have a teen version. We have a special one for transdermal piercings, which we'll talk about later. And we also have a version in Arabic. So feel free to download those and share them. The Fourth Amendment is your right to privacy, that idea that your home is your castle. And basically, the cops are not allowed to search you, search your car, search your house, touch you in any way unless certain things happen. And the most common way that the cops are going to invade your privacy is by you consenting to it. So the first thing that you need to know is that whenever you're having an interaction with a cop and they want to search your pockets, search your car, search your house, the phrase that you always want to say is, "I don't consent." Because I'll tell you that law students have a whole year of criminal law to learn all the intricacies of when a cop can search or not. And when you're standing on the side of the road stressed out, we do not expect non-lawyers to be able to analyze, does this cop really have the right to search me or not? But by saying the phrase, "I don't consent to this search," if it ends up going to court, and if it turns out that what the cop did was illegal, then by saying, "I don't consent to this search," you've given your lawyer the ability to fight for you. And oftentimes, if it turns out that the cop didn't have the right to search you, then all the evidence that they have located gets thrown out of court and the charge gets thrown away. So regardless of whether they're gonna actually rifle through your pockets or not, by saying, "I don't consent," you are protecting yourself in the event that what the cop is doing is illegal. So, and that consent, saying "I don't consent," in lawyer land, you have to say it out loud with words. In legalese, silence equals consent. So if the police officer says, "Can I search your backpack?" and you stand there silently, you've literally said, "Sure, officer, search my backpack." The same, there is some new case law that came out by the US Supreme Court where, the courts have said that if a reasonable person would have verbally responded to something that the cop said and you remain silent, that you've actually said, "Yeah, I did it." There was a case where a guy ran into a grocery store with a gun, and the cops found him in the back of the grocery store and then located the gun, and they said, "Is this your gun?" And he just stood there silently asserting his Fifth Amendment rights. And the court ruled that a normal person would have said, "No, that's not my gun," or "Yes, it was." And so by his silence, he was saying, "Yeah, that's my gun." So the courts are getting a little dicey with the Fourth Amendment. But like I said, the most common way that the cops are going to get into your business is because you have let them in. And they may threaten you and make promises and all sorts of things, but you still always want to say, "I don't consent to this search." And by the way, even 10-year-olds have been deemed to be able to give consent to the cops. So cop knocks on your door and your roommate or a 10-year-old answers the door and says, come in, or I guess you can come in, the courts have found that that is lawful consent to search the house. So out on our table, we have what's kind of like an FBI script. And we actually laminate them and give them to people to hang near their door. So whether it's a housemate or a house sitter or whoever it is, they happen to go to the door and it's the FBI or it's a cop, they can literally say, we don't consent to this search, and read from the script, which sometimes makes people feel a little bit more comfortable. The other most common way that the cops are going to get into your private matters is through a search warrant. A search warrant is just a piece of paper that's signed by a judge that has the date they're allowed to search, the time period they're allowed to search, and where they're allowed to search and what they're allowed to take. So if the search warrant says they can search the house, but it doesn't say that they can search the car, then they're limited to just searching the house. If you look out the window and you see them rifling through your glove box in your car, though, you don't want to say, hey, car is not on the search warrant, because these days the police can get on a cell phone and get what's called a telephonic warrant, which means they phone the judge and say, hey, we forgot to put car, will you add car? And the judge says, no problem, we're going to add car. And what could have been a basis to get all that evidence thrown out, you've just given them the ability to make what was illegal now legal. So lay in the weeds under those circumstances. Now, if the police show up with a warrant, they can break down your door if you're not there, or if you're there and hiding under your bed, which is strongly not advisable. If you're there, you're allowed to inspect the warrant, but then they'll likely make you sit on the couch while they rifle through the house. You don't have the right to witness them as they wander through your personal belongings. And there are also, they do have to leave an evidence sheet of what they've taken from the house, allegedly. And there are also things that are called exceptions to the search warrant, which means there are these cases that have come down through the courts that carve out ways that the cops can search you without a warrant and without your consent. The most common one, I'm not going to go over all of these, is what's called hot pursuit. If a murderer is running down the street and runs into your garage, the police are not going to need your consent or a search warrant to run after the guy in your garage because he's in hot pursuit, or an exigent circumstance is the other phrase that's used. But now once the cops are in your garage and they've caught the murderer, if they look around and see your meth lab, they're now allowed to bust you for the meth lab under an exception called the plain view exception, which means that cops can go anywhere that we can go. Anywhere the public can go, a cop can go. And if I could see your bong sitting on the coffee table through the picture window, then the cops could see it too. And that is plain view, meaning now they can enter the house and search the house because they were able to see something illegal in their plain view. That's the most common of the exceptions. The other one that most people, well, I wouldn't say most people, a lot of people may have experienced or might experience in their life is what's called the automobile exception, which means that when you get stopped for speeding or something like that, the police are allowed to look in what's called your wingspan. And we'll talk about this in a little bit more, but basically they're only allowed to search for weapons that you could use to hurt them during this interaction of trying to figure out whether you've done something wrong or not. Then turning to the First Amendment. The First Amendment, everybody knows free speech and the right to religion, but the right to assembly is something that has kind of lost some of its importance in the US. The right to assemble means that you and as many others as you desire have the right to gather up and talk about the news of the day or protest the government. And that includes on public sidewalks, on town halls, and the government is not supposed to be able to monitor that or infringe upon your rights. The same could be true for teenagers standing on the sidewalk by a bus stop. Some places have loitering laws where that could be a crime. But a sidewalk is a very protected First Amendment area. And so the government is only allowed to restrict their rights to gather up and talk about the news of the day in front of that bus stop under very specific circumstances. Now the second paragraph of this is talking about non-US citizens, whether you're undocumented or you're here on a student visa, and this actually applies to us as well when we travel to other countries. There's a clause in visas that says, I will not engage in political activities. So if you're here documented or undocumented and you're at a protest and things go a little sideways and all of a sudden you and a bunch of your friends are in jail charged with a minor crime, that could also potentially be grounds for deportation if ICE, which is Immigration and Customs Enforcement, deems that to be their desire.
Is that with a green card too, or just a visa?
With a green card as well, depending. If you're a permanent resident, then you have more protection. The more the bigger the citizenship status, the more rights you have to potentially stay here. Now, these are some clients of mine up in Idaho. They are actually blocking a highway from the megaload, which was that giant piece of equipment that was moving across the country up to the Alberta tar sands in Canada. And lots of people along the way put their bodies in front of this giant piece of equipment to try and stop or slow its progress. And the reason I have this slide up here is in most protest cases, the police are going to give what's called a trespass warning, which means the police are going to say, leave or be arrested. And under most circumstances, if you don't want to be arrested, you can simply walk away to where they tell you to go, and you're not going to be arrested. This is a pretty formal, standard part of police protocol. So if you hear, you must leave or be arrested, or you must get off the road or be arrested, you can usually bet that you really won't be arrested if you go where they say you're going to go. If you remain, though, you should definitely plan on a trip to the jailhouse. Now, the First Amendment, like I mentioned, covers freedom of speech and the right to peaceably assemble. But those rights are actually determined by where your protest is located. So there is something called a public forum. This is public sidewalks, town squares, national forest land, parks, places that are traditional places that you would expect free speech to happen. That's where you have the most protection for your First Amendment rights. The government can only limit your rights if they have a reasonable time, place, and manner restriction. Like, for instance, in a lot of communities, they can have noise ordinances, where after 10 p.m. you can't be on a bullhorn. That's a reasonable time, place, and manner restriction. Or the fact that some places will require you to get a permit before you can do your march or have your rally. The courts have deemed that a reasonable time, place, and manner restriction. But that's where you have the most expansive rights. And by the way, those rights include burning the American flag, nudity, advocating for the overthrow of government. We'll talk about the very few areas that aren't covered by the First Amendment. But as I was saying at the beginning, we really tend to overly censor ourselves when it comes to the First Amendment. People are really, the government's done a good job of making us all afraid, and we see that more in the First Amendment. In fact, for a while I was using an example. A lawyer colleague of mine was flying to a conference and wanted to bring a particular book with her. And she decided that the title of the book was too potentially inflammatory for TSA to see. So she chose to not bring this particular book with her, which I thought was just such a telling example of, the type of repression and low-level, censorship that we're all, feeling on a day-to-day basis. The contrast to a public forum is a private forum, which means if all of you decided to come into my backyard to protest, that's private property. And I have an absolute right to tell anyone to leave for any reason. Once I say leave and you don't, I can have you arrested for trespass. In Oregon, and I believe in California, malls are considered private property for the purposes of these tests. But in the middle there is what's called a quasi-public forum, which are things like university campuses. There can be some places where First Amendment would be protected, like maybe out in this forum, this atrium. But I can't walk into a biology classroom with my sign and think that I'm going to be protected in protesting in the midst of a biology lecture. So some places might be okay, others might not, and there can be different conditions placed on it. Now, the government is not allowed to restrict your constitutional rights based on the content of your speech. So if the cops have to read your sign or listen to what you're saying in order to determine whether they're going to bust you for it, then that's a content-based restriction, and that's illegal. There are some types of speech, though, that aren't protected, like yelling fire in a crowded movie theater, or what's called defamation, which is also known as slander or libel, when you knowingly tell a lie about someone that causes economic harm. That's the definition of libel. And slander means you say it out loud spoken. Libel means you write it down. That's the only distinction. But in order to be in order to be liable for defamation, you have to knowingly tell a lie with the intention of causing economic harm. So, activists working on websites and stuff are often asking me, like, are we going to get sued for defamation? And it's actually a really tough statute to prove that someone's guilty of it, particularly proving that you were the one that caused someone economic harm. The classic example is, if I published an article in my newspaper saying that my dentist had a loathsome disease. The court cases say telling the public that someone has a loathsome disease when you know it's false, and then all his clients leave his dental practice, I could be liable for defamation under those circumstances. Hate speech or true threats are another area that come up a lot in the AR scene, particularly with like home demos. Chanting, we will be back, or, we will not back down. A lot of times when SLAPP suits happen and corporations sue activists, they claim that those types of words and chants are actually threats of violence. But the courts actually have ruled that you have to really be on the verge of acting it out. So if I am making a chant, but I'm holding a gun and I'm pointing it at the house, then that's a true threat of violence. Or if I am, going like this in front of your face saying I'm going to punch you in the nose, that could be viewed as a true threat. But if I'm up here giving a lecture and I say we should all grab our pickaxes and go out there and stop that vivisection, clearly that's going to be First Amendment protected, because I don't really mean for us all to get up and run out of the house. But if you are doing public speaking, if you are doing websites, if you're doing home demos, or things where there's a higher likelihood of some unfriendly scrutiny to your actions, definitely think about and maybe look into what true threats or fighting words have been deemed to be wherever you are, whether it's California or somewhere else. And then going back to the Fifth Amendment, I said that you never have to answer questions from a cop, but this also gets to the idea that radical movements or political movements in general, often your adversary is the government. And for a long time, historically, you're either with us or you're against us. Most movements, whether it's the Black Panthers, the American Indian movement, or the animal rights movement, have had the ethic that you do not cooperate with the government against the movement that you are working for or with. And so the Fifth Amendment not only makes it so that you're not snitching on yourself, but it can also protect you against snitching on others. Whether you are subpoenaed to testify at a trial, or whether you're subpoenaed to a grand jury. We actually do a whole separate training on grand juries, but briefly, a grand jury is a secret court tribunal where a person gets subpoenaed as a witness, They show up, and in that grand jury room, there's a prosecutor and the grand jurors. There's no judge and no lawyer on the other side. So the prosecutor gets to decide what you guys as grand jurors hear. And so there's a saying that says a grand jury will indict a ham sandwich. And the reason for that saying is the prosecutor gets to decide what testimony and what evidence you all see. So if his goal is to get an indictment, is to have you charge the person, then he's going to present the evidence in a way that's going to make you indict the person. And so it's not surprising, in recent days, you've all probably read the headlines about all of these murdering cops that are not getting indicted through the grand jury process. And the reason for that, in my opinion, is that the police work hand in hand every day with prosecutors. And if the prosecutor's intention is to protect his friend, the police officer, then he's going to present evidence and testimony in a way that's going to make those grand jurors choose not to indict that person. And so a lot of control is in the hands of prosecutors. And tying really to one of the earlier panels that I attended, the overwhelming majority of prosecutors are going to be white males. And there is an inherent bias, of course, in the legal system and the court system in general. And so oftentimes, the grand jury system is one of those systems that was set up to protect white male privilege and power in a lot of different ways. If you ever do get a grand jury subpoena, please feel free to contact me right away. We can get you a lawyer right away, and there are things that we can potentially do to help you if that ever comes to be the case. Now, just so you know, with grand jury subpoenas, the FBI or whatever law enforcement division is trying to get you to come testify, they have to actually deliver a subpoena to you personally. They can't leave it with your landlord. They can't, come to your work and leave it with your boss. They actually have to physically deliver it to you. And with grand jury subpoenas, if they're knocking at your door, you don't have any obligation to open the door. They can't break the door down. Like I said, the ethic that we hope to instill in people is that you have this Fifth Amendment right. If only guilty people assert that right, then that constitutional right is diminished for all of us. It's the obligation of even people who aren't doing anything wrong to exercise their rights. I jokingly tell people, I don't know how many times I've been pulled over on the side of the road and the police are like, we want to search your car. And I'm like, go get a warrant. And I, sit there for hours on the side of the road waiting for them. And then finally they're like, well, we can't get the, go, because of course it's a form of harassment, of course. But even though I would much rather have gotten to my meeting or gone to the movie or wherever I was heading, by forcing them to comply with the Constitution and the law, and not having anything in my car to worry about, I am helping to teach police that, the Constitution and our rights really do mean something, and it's not just an excuse for guilty people to get out of trouble. So anything you say can and will be used against you. And these are a few tips that we have for interacting with cops. Number one, the first thing that I am kind of emphasizing, especially these days, is we want you to be safe. And so the first thing we want you to know is it's really important that the cops can always see your hands. These days, police are really worried about you grabbing a gun and shooting them, and they've been pretty quick to shoot us back in a lot of circumstances. So if you're in your car, put your hands on the steering wheel. If you're out on the streets, just slap them to your sides. For a couple of reasons, don't be stuffing them in your hoodie or, messing around with your pockets or anything like that. If you need to reach over to your glove box to get your registration, say what you're doing in advance. So, tell the cop, I'm going to open the glove box to get my car registration out. And, announce what you're doing. I'm reaching into my purse to get my wallet, which is where my license is. To kind of say out loud what you're doing, just for your own protection, really. Remember that police are trained to read your body language, which is the other reason why we're like, slap them down to your sides and don't move them, because fidgeting, going like this with your mouth means you're lying. So if you're covering your mouth or playing with your mouth, cops, are trained to read that and say, now you're being suspicious, because we know that that means you're being untruthful. And you are not allowed to lie to cops. It's a crime called giving false information to a police officer. But the police are absolutely allowed to lie to you in all circumstances. When they're investigating crimes, they can promise you won't go to jail, they can promise you $100,000, they can do all sorts of things, and it's absolutely unenforceable. I always joke that if a cop is undercover trying to bust a big drug dealer, and the drug dealer says, "Are you a cop?" Of course he doesn't have to say, "Well, actually, yes, I am." Of course they're allowed to lie. And as an aside to that, the cops are allowed to do drugs with you, they're allowed to have sex with you, they're allowed to commit crimes with you while undercover, and all of that is legal for them and obviously not for you. You don't have to move from where the cop found you. So if a cop says, "Hey, come down this dark alley, we want to ask you questions," you're allowed to say, "I'd rather stay here under the street light with all these witnesses around." Obviously having people around you when you are being forced to interact with a cop is generally a positive thing. You should absolutely assume that you are being both audio and video recorded by the police. And I say that, with this caveat. People, have heard nowadays that badge cams are becoming more common, where the cop has a video camera on his badge. It was supposed to, solve the problems of all these, kid murders that the cops have been doing around the country. But the police control the on and off buttons for these cameras. So if they don't want something recorded, like the beatdown they want to give you, they will turn it off then. And then when you're resisting the beatdown, they'll turn it on so they can get you resisting police. So don't rely on police cameras to save the day. That being said, you have an absolute right to record the police in public places. There are a couple of little caveats to this. If you are the target of the police contact, like they want to arrest you, they might tell you that you have to put your phone down. And if you don't, they'll say that you're interfering with their investigation. I've had clients, though, that turn the camera on and put it on the dashboard to at least audio record. The U.S. Supreme Court ruled that public servants doing public duties in public places have absolutely no expectation of privacy. So you have an absolute right. Now, they can tell you that you have to step back. They can make you go a reasonable distance from the crime scene, meaning if it's a homeless person getting an open container ticket, 3 feet could be a reasonable distance. If there's a gun involved or some shooting, a 1/4 mile could be legal. So our advice generally is if the police say step back, you should either say, "Where do you want me to go?" or you take baby step backwards until the cop goes back to what he's doing, and then you stop there and pause and continue recording. The police are not allowed to look at your cell phone. The courts have recently ruled that a cell phone is the equivalent of 100 filing cabinets worth of information. And if the cops would have needed a search warrant to get in those filing cabinets, they absolutely need a search warrant to get into your phone. Now, they may be able to seize your phone as evidence, put it in a plastic bag, take it to the cop shop, but they're not allowed to look at it until they get a search warrant or if they get a search warrant. That being said, we really advise people to keep their phones password protected, encrypted if you want, but password protected is best, just to give them an added difficulty in getting into your phone potentially. And this afternoon, I'm doing a security culture training where I'll tell you that, if they really want to get into your phone, they're going to get into your phone. But for now, we're talking about your right to refuse to consent to have them view your phone. If possible, if you have just recorded a gnarly beatdown, if you can email it to yourself or somehow get it backed up off your phone, is ideal for our purposes because you never know what's going to happen. Okay, now this part of the training is giving you some basic words when you're interacting with cops out on the street. And there are 3 different levels of interactions with cops, each one getting more serious. There's conversation, detention, and arrest. And whenever you're interacting with a cop, you should be thinking in your head, which one of these levels am I at? Because by trying to figure out what level you're at, you have different rights and responsibilities at each of these different stages. And of course, the first thing you should ever do when you're interacting with a cop is take a deep breath. Make sure that you are in control of your words and actions. Like I said, it's always a stressful situation, but the goal is to get it over with as fast as possible with as least damage as possible. So the first level is mere conversation. And as I mentioned to you before, anywhere that the public can go, cops can go. I could walk up to any one of you and ask you for your social security number. And of course, you don't have to give me that. And the same is true with cops at the conversation stage. They could walk up to any one of you and say, who's the organizer of this protest? And at the conversation stage, you have the right to say, I don't want to talk to you, and just walk away. But the way that you find out whether or not you're at conversation or detention is by asking the police officer, am I being detained? If the answer is, well, no, I wasn't really detaining you, then you know that you're at the conversation stage. And at the conversation stage, you have the right to simply walk away. If you ask, am I being detained, and the police officer says yes, then you know you're at the detention stage, and we'll talk about that in a second. Cops can't hold on to you, can't hinder your ability to walk away at the conversation stage. Also, in most states, you are not required to provide identification at this stage, meaning you do not have to give the cop your name. And in the West Coast, Washington, Oregon, California, we are not required to carry ID on us. The only person that has to have ID, picture ID, is the driver of a car. There are some states like Texas where they actually have a state law that says you must produce an ID. But out here on the West Coast, and in most states actually, only the driver has to whip out a driver's license when driving the car. And there are a couple of reasons that we suggest that you don't just turn over your driver's license, and we'll talk about them in just a second. But like I mentioned, if you're on your bike or you're on the streets and a cop walks up to you and is like, let me see your ID. Like just last night, I was sitting out here and a cop rolled up on somebody who was attending the conference and immediately was like, sit down and let me see your ID. And I had to be like, well, he just happens to be standing next to his lawyer, and we got into a very lengthy conversation with a real ignoramus of a cop. But cops always say that, and it's just looking for info. And he chose to sit down. I stood up next to him, and he did not give up his ID because he wasn't required to at that stage. Because in order for a cop to detain you, they have to believe that you've committed a crime or are about to commit a crime. That are the only 2 ways that a cop can actually detain you. So, and you have the right to know what is the reason that the cop's detaining you. So you ask, am I being detained? And the police says yes. Your very next word should be, why am I being detained? Because the cop must articulate his reasonable suspicion to believe that you have committed a crime. So he must state what is the crime that he believes that you have committed in order to detain you. And the cop last night was like, because I said so, which is the most common thing that we see from bully cops. And that is completely unlawful. If a cop does not give you the articulable suspicion of why he's detaining you, that can be grounds for your lawyer to actually get the whole case thrown out. Now, like I said, at the detention stage, now the cops are allowed to identify you. But what that means is you must provide name, address, date of birth. Those are the only 3 pieces of information: name, address, date of birth. You should never give the judicial system your social security number. Never give them your country of origin or your immigration status. It's actually illegal for them to ask that, but they still do all the time. But you are required to give name, address, date of birth. If you don't give those 3 things, then they can take you down to the cop shop and run your fingerprints in order to identify you. But they're going to say, let me see your ID. And instead you should say, my name is this, my address is this, my date of birth is this, once you've gotten past the stage where you have heard why you're being detained. There are a few reasons that we advocate that you should not just whip out your license. The first is, back in 2008, the US passed the Real ID Act, which made it virtually impossible for undocumented people to get driver's licenses. Luckily, California just passed a law to make it possible again. But for most people in the country, by us whipping out our privilege, and showing an ID right away, we're putting heat and pressure on those that just can't do that. And so in solidarity with undocumented communities, we should attempt to not provide our driver's licenses when asked, unless we're the driver of a car. And I say that knowing that there are many circumstances where a cop is going to basically threaten to take you to jail if you don't cough it up. I'm not telling you to divorce yourself from your common sense. There are circumstances where you have to, say, do I have the time to go to jail today? Is this going to be worth it? The second reason, though, is that every driver's license now in the United States has an RFID chip on the back of it. And this chip is that strip that you see on the back of your license. And if the cops run that strip, a bunch of secret information that we do not get to see is included. On mine, because a Northeast Texas police officer happened to show it to me because he didn't know. Mine says that I am an affiliate of the ELF and ALF, that I am an eco-terrorist, that I have a gang affiliation for eco-terrorism because of my clients, because of the law that I practice. It has retina scans, it has fingerprints, it has all sorts of information, contacts law enforcement have had it with you. So in the protest context, it could say suspect was cited at the last 4 home demos, which then they add a 5th to your little, list of things. So there's no reason for you to give the police that information about you unless you absolutely have to. And you don't want them adding any more stuff onto it unless you absolutely have to. And so that's an even more important reason for activists to not just be giving up that RFID chip and having cops run that information in the computer system. The other thing at the detention stage that is significant, for the first time now, the cop is going to be able to do what's called a pat-down search, which is where they pat down the outside of your clothing, and they're only supposed to be looking for weapons that you could immediately use to hurt them. So they're only allowed to search in places where they could locate a gun or a knife, for instance. They're not going to be able to open up your Altoids tin. They're not going to be able to open your wallet. But anywhere in your wingspan where you could grab, a knife or a gun, they're going to be able to look for the purposes of this search. So if you have a backpack on you, they're going to be able to open it up and look in it for weapons. When I give this training to homeless communities, I tell them if there's any way to put more than an arm's length between you and your home, your backpack, you should do it. Because if you can't reach it, they're not legally allowed to look in it. And that's why if you are stopped in your car, they're going to be able to look in the console or underneath your feet, but they need a warrant to look in the trunk. They need a warrant to get somewhere where you can't just reach, you can't obtain a weapon. But regardless of the fact that I've just told you that they're legally allowed to do this pat-down search, the first thing you should say is, I don't consent to this search. Don't resist it. Don't fight them, obviously. But just say, I don't consent to this search. And say it as many times as you feel necessary during your interaction. Say it into the camera if you can, say it into their recording device. The more you say it, the better. You also have the right to have an officer of your own gender perform that search if that officer is available. Some places in Eastern Oregon, you go 100 miles without a female cop, and they're not going to wait around for that woman to show up. But in most circumstances, you have the right to have a person of your own gender do that search. You, of course, don't, so you're saying, am I being detained? Police says yes. You say why. They give you a reason why. Next thing you should say is, I don't consent to this search. And of course, you don't want to talk to the cops. And we'll talk about invoking your Fifth Amendment right and saying, I want to remain silent and I want a lawyer as other ways in just a minute. As I mentioned before, police are allowed to lie in order to try and get information. They can say, we found coke in your trunk, or your mom snitched you out, or all sorts of things. You should never believe them. Never believe those. As stressful as it may be, you should just remain silent under those circumstances. Police will do all sorts of tactics that they learn to try and interrogate and get information out of you. But you absolutely should wait until you have a lawyer present before you engage with them. Even if you want to cooperate, the most important thing you want a lawyer around for is not only advice. We go to school for 7 years to do this stuff. And I always joke, like, you wouldn't take your own appendix out. You'd go to a doctor for that. So when you're facing jail, you should probably wait for a lawyer to show up. But the other reason is that you want a witness. If it's just you and the cop, even if what you're saying is completely true, you might say the sun rises in the east, and they either intentionally or mistakenly write, he said the sun rises in the west. Now it's your word versus a cop's word, which is never a good place to be. So just merely having another human there to be a witness can be really important as well. And in terms of promises, if a cop really wants to make a promise to you, they're going to do it in front of your lawyer. And just to be frank, cops don't have the authority to promise you won't be prosecuted or that you won't go to jail. Prosecutors have to do that. And so normally, if it's real that they're offering you an offer or a deal, it's going to be lawyer to lawyer, and that's what actually makes it legitimate. And then finally, the last stage is arrest. The police can only arrest you if they believe they have probable cause, which means it's more likely than not that you did something illegal. And as soon as the police say you're under arrest, or even if they don't say those words, if a reasonable person would know they were under arrest, you should do what's called invoke your Fifth Amendment rights, which is, I want a lawyer and I want to remain silent. Those two things. When you invoke your Fifth Amendment rights, the invocation of Fifth Amendment rights, you put a magic bubble around you that makes it so that the cops must stop questioning you. Once you say this phrase, police must stop investigating you. If they continue to question you, then it's likely that anything that you say will end up getting thrown out of court, like a confession. So I want to exercise my Fifth Amendment rights. I want to remain silent. I want a lawyer. You are allowed a reasonable number of calls, not one phone call. But if it's 3 o'clock in the morning on a Saturday night and you're drunk, the cops don't have to let you call every lawyer in the phone book because it's very unlikely you're going to reach one, at that time. But you should also know that any phone calls that you make from a jail are absolutely recorded. So you do not want to call mom saying, "Mom, I just got stopped for drunk driving. I'm wasted," because you've just admitted to the crime, and they'll play that in court, and you'll be found guilty of the charge. Also know that often, especially in the activist situation, they will plant a plainclothed police officer in the cell with you. who acts like they were in jail too, and they will be like, so what are you in for? And, they're trying to get you to admit stuff in the jail cell. So never converse about your situation with strangers in the jail. Let's see. Cops, so you have the right to medical care if you end up going to jail, but it's really shitty medical care. And if you are a diabetic or you have an inhaler, even if you have your insulin in your pocket at the time you're arrested, they're not allowed to let you use it. It has to come in through a pharmacy to make sure it's legit. So if you have a condition like that where you really need medications regularly, you need to be a real squeaky wheel, and you need to be saying, in 15 minutes I need my medication, every 5 minutes, because jails are just woefully inadequate in providing medical care. If you end up getting arrested, you're going to have handcuffs put on you. Most police departments actually have a policy that says they have to handcuff you behind your back. And there's actually a proper way to get handcuffed. And I did not say that there is a comfortable way to be handcuffed, because handcuffs suck. There is no such thing as comfortable. But you have these nerves running down the outside of your wrists called ulnar nerves. And if you are twisting your hands in handcuffs, you are applying pressure to these nerves from the handcuff. It's called a nerve crush. It can actually permanently have you lose the sensation in your hands, potentially. So the proper way to be handcuffed is, put your hands behind your back, but put your hands together like you're praying. This is the best protection for these nerves. Women in particular tend to twist their wrists looking for a more comfortable way for them to sit, and there just really isn't a way, but that twisting is what often can cause a lot of damage. If you ever have been handcuffed, sometimes people will leave and they'll be like, oh my God, my hands are tingling, I'm going to have hand issues for the rest of my life. Most people, those issues resolve within 48 hours, the tingling, numb fingers. But be careful and protect yourselves, especially the zip tie, the plastic cuffs. They tend to put those on really tight. You have the right to have your handcuffs checked for tightness, which means they're supposed to unlock them and then relock them to make sure that they are proper fitting. Proper fitting for handcuffs, they literally should only be able to get one finger in them. So they actually are pretty tight. And if you're under arrest, you're likely going to jail. Crying and debating the situation is normally not very helpful at this stage. Even a single witness or informant can create the probable cause necessary to have you arrested for a crime. So if I have a disgruntled, ex-employee that, calls the cops and says that I have dead bodies in my basement, that one phone call could be enough to have the cops, come and arrest me for dead bodies in my basement. If you commit civil disobedience, you're obviously breaking the law in front of the police, and that is the probable cause to arrest you. Most days around the country now, for civil disobedience, you should probably expect to get arrested, meaning go to jail, because they want your mugshot, they want to take pictures of your tattoos, they want to get you in these federal database systems, so they almost always are going to bring activists to jail. The one exception I would say is for juvies. People under 18 still have the advantage of being able to walk away from an arrest situation. And then there is a classification of crime called infractions or violations. Things like speeding or dog at large or less than an ounce of marijuana. Those things that are infractions or violations means that they can't take you to jail. They're unarrestable charges. All they can do is fine you for them. Things like noise ordinances, noise curfews, often the masking, the anti-masking ordinances that sometimes cities have, those are all usually violations, meaning they can give you a ticket and make you pay some money, but they can't haul you off to jail. When you get to a jail, now they're allowed to do what's called a skin search, which is different than a strip search. Strip search, they get to look up your orifices. Skin search means they can make you put jail clothes on, that you can be, all your jewelry has to come off, et cetera, et cetera. Which leads me to the mention I made of transdermal piercings, which I don't see any in the room, but does everybody know what transdermal piercings are? It's a type of piercing. It looks, sometimes it looks like just a thumbtack in somebody's cheek, but what it is it's a piercing that goes in your skin, and then there's a metal that opens up like a butterfly clip, and that's how it stays in your skin. But you can't take it out yourself. There's a special piercing tool that has to be used. And when you go to jail and you have these types of piercings, the cops are going to say, take off all your jewelry, get rid of it all. And if you say, I can't take this out, they say, well, you're either going to take it out or we're going to take it out the hard way. And they grab pliers and they think you're lying. And we actually had to sue a couple of jails for ripping the flesh off of people's faces because they just went, because they didn't know what it was. So our transdermal piercing brochure, we actually mailed them to every jail in Oregon, and it has, a picture of what a transdermal piercing is, like how they function, that they really do need piercing tools, and it says something like, if you rip someone's face off, we'll sue you too. So if you know anybody that has those types of piercing, they should stick it in their wallet, and just know that a lot of jail staff don't know what a transdermal piercing is. Jails are going to house people based on their physical anatomy. And by that, what I mean is if there is a trans person who is pre-surgery, they're going to be housed by their actual biological anatomy at that time. It doesn't matter if they've changed their ID or even changed their birth certificate. It's going to go by physical anatomy. And that's because the legal system and the jails are, way behind the times. But that can be triggering, obviously, and traumatic for people, which is why we tell everyone in advance. And it makes for another category of at-risk activist, whether you're undocumented, whether you're a diabetic, or whether you're a trans person. All of those classifications have added risks when facing arrest. Now, if you're in jail and you don't have a lawyer, and now you're being put on a video feed or you're being brought into a courtroom for your arraignment, which is where you apply for a court-appointed lawyer and you just plead not guilty. You always want to plead not guilty to everything at an arraignment. You can change your plea down the road to guilty if that's what you want to do, but if you plead guilty at your arraignment, you haven't seen the police reports, you don't have any legal advice about defenses, and you're literally throwing yourself on the mercy of the judge for punishment purposes. But oftentimes, activists will be in a situation where they kind of have to represent themselves because the lawyer is either not present or doesn't really know what they're doing. And so what you see up here is how to get yourself out of jail without paying bail. It's called release on your own recognizance. And if you can establish that you're not a safety threat and that you will come back to court, that is the test the court is supposed to be looking at to determine whether you should be OR'd or released on your own recognizance. So if you've given your name, if you have a local address you can use, if you've never failed to show up for court before, all of those things, ties to the community, all of those things you should tell the judge for yourself. Speak up for yourself and say, Your Honor, I'd like to be heard on release on my own recognizance. I'm not a safety threat. I'm going to come back to court, blah, 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 blah. And sometimes, like I said, lawyers just won't do this, or I don't know. We've had lots of activists who go through an arraignment, never gets brought up. All of a sudden, they're back in jail for another 2 weeks with no hearings to ask the judge to let them out. So if your lawyer doesn't say it for you, now you know how to say it for yourself. And that's really actually important, especially if you are arrested in rural Northeast Texas or somewhere else. So everybody's heard of Miranda rights. You have the right to remain silent. Anything you say can and will be used against you in a court of law. And you probably heard it on TV. Well, police are not required to read you your Miranda rights ever. And because I told you that police can lie to you, you should not be relying on the police to tell you what your rights are. It is not in their interests to tell you what your rights are. So you must know your rights for yourself. And so we've kind of come up with an easier version, we think, to remember your rights. Number one, I won't talk to you or anyone about anything. Because who's the only person that can ever force you to answer a question? Judge in a courtroom. I want a lawyer present before I speak to you or anyone. And make sure you've got that witness present with you. I'm not going to answer any questions or reply to any charges because you have a Fifth Amendment right and it will be used against you if you do. Don't perform any tests, consent to any searches, lineups, hair exemplars, writing exemplars, voice. There's all sorts of different tests that they can potentially, blood tests, etc. You never want to consent to any of that. They could go get a warrant and enforce you to do it, but you never want to consent to any of it. The one exception to that rule, if you have a driver's license, you consented to field sobriety tests if you are reasonably stopped by a police officer who suspects you're under the influence of intoxicants. So if you get pulled over for DUI, you have consented to field sobriety tests, which are non-testimonial tests, which means tests that don't make you snitch on yourself. So, like this one and the walk and turn or like balancing on one foot, those are non-testimonial field sobriety tests. You have to take those or you lose your license for 1 year, even if you're innocent. But how many beers have you had tonight? Or say the alphabet? Those are tests that make you snitch on yourself, so you don't have to answer those. And the breath test is also a requirement. If you refuse the breath test, you lose your license for 1 year. And in Oregon, it's actually a whole separate crime now, too. Don't sign anything, like a confession without a lawyer present. The one exception to this is normally in most jails, they won't let you out until you sign a release agreement. And so we tell people, go ahead and sign the release agreement. If it has crazy stuff in it, go to a lawyer right away. We can go ask a judge to change your release agreement, but you will not be let out, especially on your own recognizance, without signing that document. So read it carefully, but that's the one document we'll tell you can go ahead and sign. All right, so once again, mere conversation stage. The cop walks up to you and says, hey, who's the leader of your movement? And you are allowed to say, right. And it's kind of funny to make me have you say it, but what we have found is until you say these words out loud a few times and actually practice saying them out loud, A, it doesn't stick in your head as well, and B, it's just a really different experience to have to say these words out loud. And to say them in front of a cop, is even more daunting. So the more times you do it, the more desensitized you get to it. And so, the cop will say something like, well, what are you afraid of? If you didn't do anything wrong, you'd talk to me, blah, 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 blah. And you can just say, I choose not to speak with you. You can be polite, but then the other thing is we want you to walk away. Especially at a protest, don't just stand there with the cop, 6 inches from you, because he's going to keep questioning you. You have the right to slowly walk away. And the reason we say slowly walk away is, A, if you run, you're going to look like a sketch ball and you've just given the cop suspicion to come after you. B, if he changes his mind and decides now he wants you, we don't want him to jump you and injure you. So slowly walk away. Put some distance between you. Oh, and don't forget, at this stage, you don't have to give your ID. You don't even have to tell them your name. They're not allowed to pat you down or do any kind of searches, and you're free to walk away. Next stage, detention starts off the same way. Who's the leader of your protest? And you say, are you detaining me or am I free to go? And this time he says, you're being detained. And you should say, why? Yeah, why am I being detained? Make sure that they, and I always joke that the $1 million, if he says, because I said so, the $1 million response is to say, officer, I believe you must articulate the reasonable suspicion you have for detaining me today. And they will go, and then probably run away from you. And that's in the brochure if you really want all those magic words, but it's basically, what is the articulable basis, the articulable suspicion you have for detaining me, which basically just means you must put in words what you think I did. And then at the detention stage, now you have to give name, address, date of birth. That's it. Don't show your ID unless you're the driver of a car. And then they can also do that pat-down search of you. But you don't need to move, go anywhere with them. And make sure you remember what it is that they told you if they did. And then arrest, they place you under arrest, and you want to put that magic bubble around you. So you want to say, I want to remain silent, and I want a lawyer. And then zip it. Because once you put that magic bubble around you, if you start voluntarily talking, you get nervous in the backseat of the cop car and you just start blathering, you've just popped your bubble. Now they can start questioning you again. But just by repeating that phrase, you can put the bubble back around you. So if you freak out and pop the bubble, just restate the phrase, and then the bubble goes back around you. Okay, so this stuff is all for the afternoon talk. You're getting a highlight quickly. Don't look. It is a reasonable amount of time. So it kind of depends on the circumstance. And it's tough to prove that they have detained you for too long. The other thing I will throw in, especially for California, especially for LA area folks, the police often will say you must sit down on the curb or sit on the ground, when they're detaining you. And especially for young men, this is highly offensive to be, told to sit on the ground like a dog. But the courts actually have ruled that it is reasonable for the police to order someone to sit on the ground while being detained if they believe that the person is a flight risk, if they think they're going to flee. Because apparently making you sit on the ground means that you can't jump up and run, quite as fast. So that has been deemed lawful, especially down here. Okay, just really briefly, I just wanted to cover a couple of short things for folks that are working with undocumented communities. ICE, which stands for Immigration and Customs Enforcement, La Migra, police can come to your door with a warrant and bust your door down. ICE can come to your door with a warrant. They're not allowed in. You can literally tell them to slip the papers under the door, look at them, slip them back out, and say, go away. ICE does not have the power to break down a door or to enter without consent. So if ICE ever shows up at the door, you just don't open the door, you don't consent. The only way that they can actually get the person that has a deportation warrant is by physically seizing them. If you don't assert your rights, you could be deported within 48 hours. You can literally sign away your own rights to deportation proceedings. You are entitled to an interpreter of your native language, meaning if you speak a rare Oaxacan dialect, they have to find somebody to translate that. And they use cell phones now. It's an operator, and they kind of do it by cell phone. But don't rely on friends or family members to translate for you under stressful, high-pressure legal situations. An interpreter that the judicial system uses takes an oath that they will accurately transcribe every word, so they're not allowed to make inferences or incorrectly translate. If they do, that can be a defense to you down the road. If you give false information about your immigration status, if you say you're a U.S. citizen and you're not, you can be barred for the rest of your life from ever gaining status. So the number one thing you should never do, you should zip it before you ever lie about your immigration status, because you literally will destroy any chance of ever getting status. Another thing that a lot of people don't know, deportation proceedings nowadays, maybe not down here, but everywhere else in the country, are taking between 1 to 2 years for the process. So, mom gets arrested on a deportation warrant and is sitting in a deportation facility. After 6 months of being there, the state is legally allowed to terminate their parental rights and give the children up for adoption after 6 months. And so we strongly advise families to get a power of attorney, which is just a piece of paper that says, I give my US citizen friend permission to go get my kids and caretake them while we figure out what to do. You know, rather than losing the kids forever into an adoption foster system that's insane, by having that piece of paper, it allows me to go to Child Protective Services, get those kids, take them back to my house, and then, you know, if mom gets deported to Mexico and she wants the kids to get on the Greyhound, you know, we can do that. You know, mom and me can make all sorts of agreements on what's going to happen, but we don't want to take that right away from them. Also, you can post bail if you are detained under deportation. The number one way, and I don't know if this is true for Southern California, but for the rest of the country, the number one way that people end up getting deported, particularly men, are by driving infractions, by not having a driver's license, which is an arrestable offense. Usually within 8 to 12 hours of being in a jail, ICE is running the jail databases looking for undocumented people to put immigration holds on. So you have about 8 hours from the time somebody is arrested to get them out of jail before they would potentially end up on an ICE hold. And drunk driving is, you know, the number one way that we're seeing undocumented Latino men getting deported. These are just some tactics on civil disobedience. You know, these are called sleeping dragons. And the reason that this is an effective tactic is, can you imagine if all of these cops had to lift this giant mass of humans and get them out of this office? They are all locked into these pipes, you know, through their arms. This is what is a sleeping dragon, in case you don't know. It's a piece of PVC pipe with a rod going through the middle of it, and I have a chain around my wrist with a carabiner on it, and I clip the carabiner onto here so that when they pull on my arm, it's like I can't get my arm, you know, I'm stuck in there. And then they wrap these in all sorts of things, most often duct tape, because when the cops use these metal grinders to try to cut through these PVC pipes, the blades get all gummed up with the duct tape, and it's fun to watch them lose their proverbial SHIT. And that's what the sleeping dragon looks like, and that's why it's an effective blockade tactic. Now, the reason I'm telling you this out loud in a recorded situation is this slide I actually got from TransCanada, who is the corporation responsible for the KXL pipeline. They did a PowerPoint presentation where they had this slide, and they were showing the FBI and all these local law enforcements about these tactics. And then finally, I think I've got like 1 minute. I will quickly talk about SLAP suits, which stand for Strategic Lawsuits Against Public Participation. This is where corporations sue activists in state court, civil court. So this isn't criminal. You don't go to jail. It's a civil lawsuit for money or for injunctions. So corporation sues, you know, an effective campaign trying to get them to shut up and stop talking naughty about their product. They have been highly unsuccessful in using these against activist campaigns. Important to know, if you ever do get served with a SLAP suit, you have 30 days to mount your defenses before you waive them, so you need to immediately get to a lawyer. And these are all the states that have anti-SLAP laws, meaning places that say your First Amendment rights are more important than corporate profits. It includes California, as you can see. And this is just kind of what a SLAP suit looks like, in case you're ever interested. And in this case, this was TransCanada against the KXL pipeline, and they were seeking an injunction having people not be able to go within a certain distance from the pipeline route. That's normally what they're going to do. You know, you can't go a certain distance from the corporate headquarters, or, you know, right now there's a SLAP suit against some of the activists involved in the home demo that will happen tomorrow, and the SLAP suit seeks an injunction saying that they can't go within a certain distance of the homes of these people that they were targeting. And I think that is probably about it. So This video, all of our resources, like I mentioned, this actual PowerPoint are all on our website. Obviously, hearing it one time through is normally not enough to really get it into your brain. But please, feel free to look online. And, like I said, if you do have follow-up questions, you are welcome. And if anybody does have any quick questions, I know I saw your hand and I forgot to go back to you, but if anybody does have any quick questions until the door opens and the next folks come in, I'm happy to answer them. Yeah. No. If they did lie, the search would be illegal. But you do have the right to inspect it. But a lot of times they'll be like, well, it's on its way. You should still say, I don't consent. Because if it turns out that they didn't have a warrant and you say, I don't consent, then you're protected. Everything would get thrown out.
So you remained in your car when they said they didn't have a warrant because you had to stay there. So if they come and you're saying, do you have a warrant to search my car? And they say no, you're not allowed to drive off, right?
Correct, yeah.
Is that the same in your house? Would you feel that if they came to your house to search and you said you have a warrant, they said no, would you leave your house and go do groceries or no?
Well, so if they come to your house and they say they don't have a warrant and you say, I don't consent, they should be leaving unless they have some exigent circumstance. Oftentimes they will say you can leave, and sometimes people will go next door and call people to get the video cameras to come now and film it. Other times people really try to stay in the living room and look at what's being carried out. If it were me, I would be trying to stay around to see what exactly they are taking out of my house. But it depends on the circumstances. If you're afraid you might end up getting arrested, then walking away might be safer for you.
And if you do have an interaction with the cop, like when we were here on campus doing the review last year, we ended up having to leave, the cops made us leave, and the cop said to me, I need your identification for the write-up that I'm doing. And he told me that to give him my ID. So I gave it to him. But would he, like if he's writing a report for his boss to say this incident occurred, do I have to give him my ID?
Did he think that you guys had broken the law?
We were getting kicked off for, basically for trespassing, I guess.
Well-
We were trying to instill our First Amendment rights, and
So if he says you're being detained, or that he thinks you're committing a crime and he's stated what crime it is, then you would have to give name, address, date of birth. But if he's just saying, I don't think anything illegal happened here, but I just want your name because I'm going to write a report that you were here, then no, you wouldn't have to give it
you
up.
have to get off or you will be arrested, so we said fine, we'll leave it.
Okay, well, so
So then if we were leaving and he said, but I want your information because I'm going to write a report about this.
then I probably would have said, well, are you detaining me or am I free to leave? Yeah, and don't give your ID up though. You still, yeah.
Sometimes I've noticed that people don't often hear the audio to me for the request to me, especially in noisy demos.
Uh-huh.
So that's like an exception to watch out for, like when you're on the street.
Mm-hmm.
You don't always hear the volume. It depends on the folks to me. If they're angry about something else and they want to cite you, the moment you step on the street, they fall into grand infraction.
Yeah.
And the Fifth Amendment, he said that actually prevents being forced to snitch against others. I didn't know that. I thought they can give you some kind of a news against prosecution and then you're forced to testify.
In the grand jury context, they can provide you with what's called transactional immunity, which strips you of your Fifth Amendment right to incriminate yourself or others. But in order for immunity to be applied, in the federal circumstance, the head U.S. attorney has to grant that. It's not something they can do in like 5 minutes. It's a process. They have to apply for it. The chief U.S. attorney has to say yes. And then in that circumstance, if you continued to refuse, you could potentially be held in contempt of court for refusing at that point. Correct. Yeah.
What are like police protocols if you like if you're driving and they ask for identification and they don't think your identification matches like you, i.e. like especially trans situations,
Mhm.
like the gender is different. Identification. What is the protocol or what do you guys do that?
Well, so especially in the trans situation, sometimes what it has, I mean, if you can recite the address information, et cetera, they normally should accept that. But I have had a couple of clients that were taken down to the jail for fingerprint running. And that's the absolute verification of identity. So in the event, in that worst case scenario, where they're claiming you're using a false ID or whatever, you can say, look, you can run my prints, and they will match.